Hello, my name is Luna, and this is the Morbid Flex. January 24th, 2023, Duxbury, Massachusetts. Lindsay Clancy was a labor and delivery nurse at Massachusetts General Hospital. Her husband was Patrick Clancy. Their children were Cora, born December 4th, 2017, Dawson, born September 30th, 2019, and Callan, born May 26th, 2022. That night, she sent Patrick out of the house. At 5:15 in the evening, she called a restaurant and placed a takeout order. At 5:32, he was at the drugstore, buying medicine for Cora, calling her about which one. He said she seemed busy. Around 6:09, he came home. The 3 children were dead. Cora, 5 years old. Dawson, 3. Callan, 8 months old, would die 3 days later, on January 27th. Lindsay had jumped from a second-story window. She survived. She was left paralyzed from the waist down. She has admitted the killings. That is not the fight in Plymouth. The fight is whether the law will treat those killings as murder or as a medical event with no crime in it. February 7th, 2023. Arraignment, 3 counts of first-degree murder. She pleaded not guilty. July 27th, 2026. The trial opened in Plymouth Superior Court before Judge William Sullivan. Weeks of testimony, more than 70 witnesses. Both sides agree she killed the children. They do not agree on her mind. The defense says she was not criminally responsible. Postpartum psychosis, overmedication, a break from reality. They say she could not appreciate that it was wrong or could not stop herself. Prosecutors say she planned it, that she knew it was wrong. That sending her husband out was not a symptom, it was a step. I am not going to walk you through the killings. You do not need a play-by-play to understand a sequence. August 27th, 2026. Closing arguments are finished. The jury is deliberating. 12 jurors, 9 women, 3 men. As of this recording, there is no verdict. I will not invent one. The law in front of them is not a slogan. First-degree murder, second-degree murder, manslaughter, or not guilty by reason of lack of criminal responsibility. That last option is the door a lot of people on the sidewalk are praying stays open. Now look at that sidewalk. August 20th, 2026. Hundreds of people outside court, a sea of pink. A gathering called Stand in Peace for Lindsay. Shirts printed with slogans, she needed help, peace for Lindsay, believe. She's not alone. That last line ran as a Boston Herald headline the same day. A silent rally with hearts made of hands, as if this were a vigil for a patient, not a trial for 3 dead children. Patrick, in the days after the killings, asked the public to forgive her. He said she was ill. Then, in April 2026, he filed for divorce and remarried. Forgiveness and a marriage ending can both be true. Neither one is a verdict. The media frame is medical. The victim in that frame is Lindsay, motherhood, medications, a system that failed her. The children recede. They become the sad thing that happened instead of the thing she did. So here is the question this channel exists to ask. How can so many people, especially women identifying as mothers, treat this as okay? Or if not okay, as unpunishable? How does a triple child homicide become a wellness story with a courtroom attached? I am going to be blunt, because somebody will try to twist the question. I am not saying women as a class think killing children is acceptable. That claim is cheap, and it is false. Most mothers would tear the world in half to keep their kids alive. That is not the argument. The argument is about this crowd, this frame, this reflex. And from here on, you are hearing a take. Opinion, not a verdict, not a diagnosis, not a closing argument in Plymouth, a take. The story spreads because it is useful. It spreads especially among women who recognize themselves in overwhelmed motherhood. The nights that do not end. The prescriptions, the fear that you are failing, the fear that no one in a white coat is actually listening. That identification is real. Postpartum illness is real. Postpartum psychosis is real and rare and dangerous. Destigmatizing it is a decent project. It becomes an indecent one when the stigma you are trying to kill is the idea that a homicide still belongs to the person who committed it. That is the line. Illness can explain suffering. It does not automatically erase intent. Look at the public record spine of intent. The errand, 5:15, takeout call, 532 drugstore, 609 home. You do not clear the only other adult from a house by accident. You do not wait until the person who could stop you is standing in a parking lot with takeout. That is a sequence. Sequences are what planning looks like when people are afraid of the word planned. Then the searches, introduced at trial as evidence, not gore, search terms on a phone. Quote, where is the carotid artery? Quote, how to slit your throat to die. Quote, can you treat a sociopath? Psychosis, hallucinations. Those queries are in the record. The jury heard them. You can hear them without a recreation. Prosecutors told the jury her wounds looked superficial. Emergency department witnesses said they were not bleeding the way a determined attempt would bleed. The state argued the suicide was staged. The defense said cold weather. I am not a medical examiner. I am telling you what each side put in front of 12 people. Then the medications from public testimony: Zoloft, Ativan, Prozac, Seroquel, Ambien, Trazodone, Klonopin, Remeron, Amitriptyline. A stack of prescriptions from the fall of 2022 into January. Emergency rooms. A day program that thought she was over-medicated. McLean Hospital in early January. Discharged January 5th. 19 days later, the children were dead. This is not the first time a country has been asked to swallow that sequence. Houston, 2001. Andrea Yates drowned her 5 children. Same family of defense. Postpartum psychosis. A mother. A horror people wanted to file under illness so they would not have to file it under choice. The first jury convicted her. That conviction was reversed. The 2006 retrial found her not guilty by reason of insanity. She was committed. She was not sent home as if nothing had happened. But the public lesson that survived was sloppier than the verdict. The lesson was this: a mother who does this must have been insane because a real mother could not choose it. If a real mother cannot choose this, then every mother who does this was never choosing. Intent becomes unthinkable. Unthinkable things do not get a moral adult attached to them. That is in group protection. The category is us, mothers, women who have been dismissed. Women handed a stack of pills and a pamphlet. If she can be a monster, then the in-group can produce monsters. So she cannot be a monster. She can only be a patient. The crime has to become a symptom, or the story of the group cracks. Destigmatizing postpartum illness, past the point of the crime, is how you get pink shirts outside a murder trial. It is how a medical frame swallows a moral frame. It is how 3 names, Cora, Dawson, Callan, become scenery in a conversation about how hard motherhood is. Motherhood is hard. That is not a defense to homicide. Seeking help is not a confession of innocence. Being over-medicated, if that is what the records show, is a medical failure worth rage. None of those facts are a verdict. They are the terrain. What they are not is a spell that turns intent into mist. So I will say the take again, labeled, so nobody can pretend they missed the sticker. My take is that a culture that cannot look at the sent him out fact without flinching would rather protect a self-image than look at intent. My take is that the Yates template taught a generation to reach for psychosis first and last, because the alternative is unbearable. That a mother can know, and plan, and still do it. My take is that destigmatizing illness is not the same project as making child murder unpunishable. And my take is that the people in pink are allowed to care about mental health. They are not entitled to launder 3 homicides into a wellness campaign. Care is not the same thing as erasure. A courtroom is not a support group with better lighting. Cora was 5, Dawson was 3, Callan was 8 months. Those are not props in a debate about stigma. Those are the entire case. The children do not get a trial. They got a night their father was sent out of the house, and then they were gone. August 27, 2026. Plymouth. The jury has the law, the experts, and the record. They have not spoken. Until they do not tell me this is already settled as medicine. And do not tell me that asking about intent is hate. Regardless of all that has been said, you should never hurt children, and that's my opinion. Thank you for watching. Please like and subscribe.